The way landlords rent out properties to tenants in England is going to change fundamentally on the 1st of May 2026. And this is because it's when the tenancy reforms in the Renters' Rights Act will come into force. These are big changes, and there's a lot that landlords will need to do differently. And if you're a landlord, you need to understand what's coming, even if you use agents. And in this video, I help you exactly with that. I go through the 10 key changes that will go live on the 1st of May 2026, so you can understand the rules that you'll need to comply with and avoid the civil penalties of up to £7,000 for breaches of almost all of the new rules. Sure, there's a lot that's changing and we will have to do things differently, but in this video, I explain it in a drama-free, straightforward way, as once you understand the rules, you'll know what to do and you'll be able to take it all in your stride. Then it will become the way that we do things. And who am I? I'm Suzanne Smith, a former corporate solicitor turned landlord, and I run the Independent Landlord website and this YouTube channel to bring reliable, practical information to everyone in the private rented sector. And you can keep up to date with what's happening during this period of immense change for free by subscribing to my weekly newsletter. You can find the link on the independentlandlord.com/YouTube, where you'll find links to lots of other free resources about the Renters' Rights Act, and also a link to join my membership if you'd like to do my courses, ask me questions, and have access to the many downloadable checklists and templates I've put in there. Right, let's get started with the first of the 10 big changes. Number 1, from the 1st of May, ASTs will automatically turn into assured periodic tenancies, or APTs, overnight. The new APTs will have no fixed terms, and even if the AST the day before was a fixed term, it will become periodic on the 1st of May. And there'll be rolling tenancies. And this rule is the same for all private landlords in England, no exceptions for students unless they're private, purpose-built student accommodation. And if a landlord or a letting agent tries to let on a fixed term basis after the 1st of May 2026, the local council will be able to impose a civil penalty of up to £7,000. Number 2, tenant notices to quit. Part of the new compulsory periodic tenancy is that tenants will be able to terminate it with 2 months' notice to quit in writing, unless if the landlord agrees to less. And as is the case now, a notice to quit by one joint tenant can end the tenancy for all. And tenants will be able to withdraw a notice to quit if the landlord agrees. And if there's more than one tenant, they'll all have to agree. Landlords will not be able to stipulate how they serve the notice to quit, so long as it's in writing. And the government guidance says that tenants can even serve it by text. This is a big change, as tenants won't be tied in for a minimum period other than the 2 months. Number 3, advertising the proposed rent. It will be compulsory for all listings from the 1st of May, whether it's on the portals, Facebook, or even in a shop window, to state the proposed rent. And this proposed rent will be a maximum, and we won't be able to ask for offers over this amount, and that's called rental bidding, which is going to be banned. So this means it's important to pitch the proposed rent right. And breach of this comes with the risk of a civil penalty from the local authority of up to £7,000. But be aware that tenants will be able to challenge the starting rent in the first 6 months of a tenancy at the first tier tribunal, and the judge will be able to reduce the rent if they think it's above the open market rent for a similar property in the area. So keep records of other offers and why the rent is justifiable, just in case. Number 4, rent periods and payments. The rent will have to be payable for periods of no more than 1 month. You can have rent periods for anything under a month, for instance, weekly or fortnightly, but they're not very common. Apart from the first rent payment, the rent can't be due before the start of the relevant rent period. And this means that a landlord cannot have a legally binding clause in a new tenancy agreement that says that the rent is payable before the start of the relevant rent period. And there's an exception for the initial rent payment, which can be paid before the tenancy starts, as long as it's after the tenancy's been signed. A tenant will be able to pay in advance voluntarily once the tenancy starts. And as an aside, if you have an existing tenancy with a rent payable in advance, that will still be binding and it will still be fine for the tenants to pay that rent in advance. Number 5, prohibited pre-tenancy rent payments. Well, speaking of rent in advance, when you get an offer from a tenant after the 1st of May and they pass referencing and you want to go ahead with them, it's really important that you do not ask them for the first month's rent, and you must not accept rent before you both sign if they send it to you at the same time as, say, the holding deposit or the tenancy deposit. This is because it will be a prohibited pre-tenancy rent payment if you ask for, encourage, or accept a rent payment before the agreement is signed. And these payments will be banned under the Tenant Fees Act from the 1st of May. And the penalty here is up to £5,000. Once you've both entered into the agreement, the tenant can pay rent in advance voluntarily. But if you have a clause in a new tenancy agreement that requires them to pay rent in advance, that won't be binding and the tenant will be able to ignore it. Number 6, rental discrimination. The Renters' Rights Act introduces a new concept of rental discrimination, which means that landlords and agents cannot have a blanket ban on families or applicants who receive benefits. There are some exceptions. For instance, where a property is unsuitable for families, such as a retirement village where the residents need to be over 55, or having a child living in an HMO, or if the property is too small for children. For applicants who receive benefits, you will be able to turn them down if their total income, including benefits, means that they cannot afford the rent. You can also turn them down for good objective reasons, such as a failed credit check or a bad landlord reference. By the way, always get a reference from the previous landlord, as the current one might not tell you the whole truth. If the local authority believe on a balance of probabilities, it means more likely than not that you've been guilty of rental discrimination after the 1st of May, they'll be able to impose a civil penalty of up to £7,000. But before we move into the next one, I'd like to correct a common myth. You can actually get rent guarantee insurance for people who receive benefits if they have a good credit history. And I know because I've been able to get rent guarantee insurance for tenants who receive universal credit. They manage their money really well and they've never been in rent arrears. And that's what's important, finding tenants who have a track record of paying rent. And there are plenty of high earners who don't receive benefits, who have a bad credit history. Number 7, increasing rent. The Renters' Rights Act also changes the way that landlords and letting agents will be able to increase rent. From the 1st of May, the only way you'll be able to increase rent will be by using the amended process in Section 13 of the Housing Act 1988, using a new form 4A, which we'll be able to get from the tenancy forms page on gov.uk when it's eventually published. You'll need to give at least 2 months' notice to expire on the date that the new rent will be payable. Any other way will be invalid. If you have a rent review clause, that will be null and void. You won't be able to agree it informally and you won't be able to renew a tenancy as there will be no renewals. Fixed terms will end. Tenants will be able to challenge the rent increase at the first tier tribunal, and that will delay the rent increase until after the judge comes to a decision. The judge will be able to reduce the rent if they believe it's above the open market value. There is no civil penalty for not using the Section 13 process, but if you try to increase the rent without serving first Form 4A, the rent increase will be null and void and the tenants will be able to ignore it. Number 8, tenants' right to a pet. From the 1st of May, tenants will have the right to have a pet so long as they ask for the landlord for permission using the process set out in Section 11 of the Renters' Rights Act. The landlord will be able to refuse to give consent if they have a good reason, such as it's a leasehold property and the freeholder refuses to give consent, or perhaps the lease prohibits pets. Another reason is if the pet is unsuitable for the property, a Great Dane in a small studio, or maybe the number of pets is too high for the property, say 3 large dogs in a small flat. You'll also be able to turn it down if it's an HMO. And I would also say that it would be reasonable to refuse if the landlord has reasonable concerns about the welfare of the pet. For instance, a request to keep a dog when the tenants do not work from home and the dog will be left for more than 4 hours at a time on a regular basis. And the final one is the landlord has allergies to the pet in question. Tenants will need to apply in writing and give information about the pet. And the landlord will have 28 days to apply, but can ask for more information, in which case the 28 days will be extended. The landlord should only give consent for that particular pet and must make it clear that they need to apply for additional pets. And for members of the Independent Landlord Hub, you can download and adapt my pet policy. Landlords won't be able to take a higher deposit than the normal 5 weeks for pets, and they won't be able to make the tenant take out insurance for pet damage. That was originally in the bill when it was going through Parliament, but it was taken out. Number 9, abolition of Section 21, the so-called no-fault eviction notices under Section 21 of the Housing Act 1988. Well, landlords will not be able to issue new Section 21 notices from the 1st of May. Any pending notices as of the 1st of May will still potentially be valid, but they will expire if the landlord hasn't applied to the court to issue a claim form for an order for possession by close of business on the 31st of July. If you're thinking of using a Section 21 notice, do use a specialist solicitor, as we really are in the last chance saloon times. From the 1st of May, if a landlord tries to serve a new Section 21 notice or tries to evict the tenants using any other method other than a Section 8 notice, which I'll get into a minute, it will be a breach of the rules, and the local authority will be able to impose a civil penalty of up to £7,000. And finally, number 10, Section 8, the new rules for evicting tenants. From the 1st of May, the only way that landlords will be able to evict a tenant will be by having a ground under Section 8 of the Housing Act 1988 and going through the process. Grounds include selling up, moving in, rent arrears, and there's a ground for HMOs with full-time students. There's quite a few hoops to jump through. So again, do get legal advice. Right, I appreciate that's quite a lot to take in. And if you found this video useful and you'd like more support, including the ability to ask me questions on twice monthly live streams, plus my courses, templates, checklists, well, join the Independent Landlord Hub. You can find out more here at theindependentlandlord.com/hub. And there's a great community in there as well. I really love running it. If you want to know more about the transition rules for existing tenancies and what you have to do, check out this video here and see you soon, and hopefully in the hub.